Good morning, evening, afternoon. Hello. Hope everybody is well. Whoever is here today. Okay. Well, this is interesting. Anyway, hope everybody is here. If you are not getting this, then please let me know. If you are, then all good. So I have been having troubles with my stream, so I'm going to give it a couple of seconds. I see there's like a small number of people who are joining. I did kind of put this on really at the last moment, so perhaps people are coming in later, but perhaps not. So we'll just kind of go start. I have a bunch of stuff to talk about. There's a deposition tomorrow, and I will be talking about it after it happens. That's with regard to Gtii. I'm going to talk about other things other than Gtii coming up, including about Richard Kahn and Darren Indyke, who are both the professionals who helped Jeffrey Epstein and are the beneficiaries of the trust, who claim not to know about anything that went on. I'm going to do a separate video on that at some point in time, but for today's purposes, hello. And I wanted to talk to you about Gtii. And obviously, before I get to Gtii, I have a few little hopes at humor for you. I used to be addicted to soap, but I'm clean now. I used to have a handle on life, but it broke. I'm on a 30-day diet. So far, I've lost 15 days. I'm slowly getting over my fear of speed bumps. I told my wife to embrace her mistakes. She gave me a big hug. Why do cows have hooves and not feet? They lack toes. And last but not least, my friend's bakery burned down. Now his business is toast. All right. So what I was going to talk about was various aspects of Gtii for whatever it's worth. And I have an order. And then I'm going to talk about a filing that came in recently. And it'll make sense. So first of all, I want to talk about the audit. I mentioned the audit before. I posted a tweet on X saying that I'd spoken to or communicated with Dylan, and he indicated they were diligent working on the audit, etc. I challenged that and went from there. So I've been thinking about that, and it again, I'm not saying there's any shenanigans going on, but it makes me very uncomfortable, the status of the audit. Why does it make me uncomfortable? I think it was September of 2024. The order appointing the receiver was entered by the court. The court indicated, at least in the order, it indicated that or at least it sounded like the audit and filings would be done in short time frame. So that's September of 2024. We're now November 23rd of 2025. So that's what, 14, 15 months later. And we have not seen the audit. Will we see the audit at some point in time? I'm sure we will. But it made me think about it, despite the fact that I was reassured by counsel as to that there was nothing going on. But it made me think, if in the order it reflected that the documents would be completed in a short time frame, why is it taking so long? And why did they choose to use the auditor at first that Gtii had chosen? If you recall, that was the auditor in Orange County. Eventually, they didn't cooperate with the receiver. So I don't know why the receiver continued to work with them, but they did, and it's kind of wasted time and money and effort and delay. Poor choice, in my opinion. So if you recall, they used Borgers, who was shut down by the SEC. They went to the Orange County auditors. the receiver stuck with them for some reason. They didn't provide what the receiver needed. Then they went to another auditor. That's the current one. It's taken about a year. They haven't completed it. So I don't, again, not saying any shenanigans, but clearly they don't have the resources to complete the audit. And if my view is if the receiver had gone to and found an auditor that could complete the transaction in a specified period of time, they would have paid more money, but they could have certainly found them. So they could have gone out and not go out to a mom and pop place, say, we need this done in 6 months, we'll pay you for it. But they elected not to. And as a result, we're over a year, and we're still waiting with no indication of a specific time frame. And obviously, if GTII is to trade or do anything, to exist, to do business in the future, the audit has to be completed and the SEC filings have to be, and there's no indication of a specific date. And again, I don't think there's any viable excuse justifying the delay. And there has been no effort by the receiver to explain the delay, the length in time, and why the original order was inconsistent with what has happened, and why he didn't correct that record, and why he didn't elect to fire the first auditor who wasn't cooperative, and why, when the first auditor wasn't cooperative, why they didn't sue that auditor. All those things have not been explained, and all it has resulted in delay. That's the bottom line. And I don't know, I'm guessing it's possible, but I don't know if there were, because I would think that the AI-versity deal or any deal couldn't be done until the audit was done. And I can only imagine there were discussions between the parties about the audit. And I don't know if those representations by the receiver as to the audit to any target were accurate either. I'd be interested to see what the receiver told AI-versity. I don't know. Did they share? Have they shared anything with them? Have they seen anything? When? We're just kind of circling. And there's still trading going on, because I saw one day last week, I think there was like 250,000 shares approximately were traded. So it wasn't insignificant. So the fact that the audit is still being dicked around, that's my legal term, concerns me, and there's no justification. And if they can't finish it, hire somebody else that can. And again, there's no justification for not letting us know what's going on. I know the story is about the trading, but the only people that can trade are not us. So that, I'm throwing that out there. Audit, still concerned. I don't think there's been a proper justification for the delay or explanation. So that's one. So I just threw out the audit, and I don't know again what any communication was about the audit between AI-versity and John Forster also. So we'll have to see how that plays out. So that's one. Two, depo. There's a deposition tomorrow. It's of a person by the name of Rachel Wallet, Wallitt. She's connected somehow to the Rose. You remember we talked about the charities that receive shares of stock from David Reichman, and the not only did the receiver question those shares, but others questioned them, and one of them related to the Hans and Rosie Epstein Foundation. Anybody has an Epstein attached to their name is, in my mind, should be questioned. But the Hans and Rosie Epstein Foundation, if you recall, they received millions of shares for what, I don't know. And apparently this deponent is the person who's the person from that charity. They got millions of shares. So it'll be interesting to hear what the story is. And I will report on the story once it occurs. It's set to start tomorrow, I think at noon Eastern time. It's on the West Coast. So we will see, and I'll report on it. This is one of several depositions that are going forward. To the extent I can attend all these depositions, I will, and I'll report on them and give you context and kind of critique the performances also. So Another thing that has come in is I received a filing from the court, and the filing was regarding Bronx Eye Care, and it related to, if you recall, there were some claims that were filed against GTII, monetary claims. One of them was from Bronx Eye Care, and apparently some agreement, at least a tentative agreement, has been reached, and a motion will be filed and it'll be presented to the court. We haven't yet seen what the terms of the agreement are. There may have been some representations made by GTII or David Reichman. I don't know what the specific details were, but I'm sure in the agreement we will see it. And they just filed that saying that there will be some type of motion that's filed to affirm that particular agreement. And when we see what that is, we'll talk about it and report on that. And that involves Bronx Family Eye Care, Nikolay Bitsenko, and Michael Andreev. I hope I pronounced those names correctly. So that's that. So next we have and this is where I'm going to focus some attention, because I want to make a point here. And this reminds me of kind of the Trento stuff. So when I'm going through these this is a document that was filed. If I was opposing this document, these are some of the things I would raise, and hopefully the Receivers Council will also raise these. I have indicated to the receiver to watch this particular portion of the live stream, just so they can comment on it, so they find out what's going on. So if you recall, there were two attorneys, Warren Markowitz and Scott Oliphant, who had got shares. There was that motion where the receiver froze all the shares. So they opposed that freezing. They filed a motion to try to undo that freeze. And then the Receivers Council filed an opposition, and they also objected to their filing anything because there was a conflict. In other words, the attorney filing this document, Scott Oliphant, who represented GTII, the Receivers Council says there's a conflict and you're working against the interest of GTII and you shouldn't be moving forward. So I'm not going to even discuss that other than in the filing. So first of all, the document, and hopefully you'll find some of this entertaining as I kind of rip these guys to shreds. But think about this. So this guy is approaching the court saying that he provided valuable services to GTII, and he's trying to, and it was also some kind of communication with the counsel for the receiver, and in that communication, my reading of it was that Oliphant basically said to the court, F you, I'm not going to be subject to your jurisdiction. He tries to backpedal, you will see, but I thought it was pretty over-the-top language by Oliphant, showed complete disregard for the court. And could be interested to hear what the judge says when this comes before them. I, in fact, was thinking these guys would dump out of here because they wouldn't want to face the judge with this garbage, but they do. So this guy is claiming, and basically, he provided valuable services to GTII, and doesn't have any insider information or any information related to GTII that would cause a conflict. So if I were in his shoes, and the same with Markowitz, who's subject to the same order, and I tried to get a hold of Markowitz when I started in 2024, sent him, I think, along with everybody else, sent a bunch of emails they didn't respond to. I think I called. I might have spoken to him one. All I know, he was pretty unhelpful, non-responsive. Oliphant, I never reached out to. There was another attorney that I reached out to at GTII because I did videos on this. His name was Jack Fattal, Fattal, I believe. I think he was a Canadian attorney, but somehow he was representing GTII. And he's the one who told the story about they were going to file these. They were going to do something with regard to a transaction, and they were going to file all their filings, and instead that didn't happen. So some people might say that what the attorney said was false, misleading, and actionable. Some people might say that. Maybe even I might say that. But so we've had dealings with their attorneys. So far, dealings with their attorneys have been less than optimal, let's just say. So Oliphant is basically now trying to say that he did good for GTII and there's no conflict. And to justify that, he's filing a bunch of paperwork. Now, in the paperwork, though, the paperwork is garbage. In my opinion, it's garbage. And I'm going to lay out a few reasons why. So it's filed November 20th, this document. And the document is called, I'm going to read it because it's going to be important because you're going to see all the inconsistencies and the lack of care, which comes down to it. And it's not just a lack of care in Oliphant, it's a lack of care of Markowitz not paying attention to a document that he's responsible for too. He has a declaration here. And these are the guys who represented GTII. So it's important that these were the choices they made because Reichman chose Markowitz. Markowitz chose, apparently, Oliphant. All bad choices. So the document is called Warren Markowitz and CYA Cover Your Ass-esque Holdings LLC's opposition to omnibus receiver Paul Strickland's motion to disqualify Scott Oliphant. So this is an opposition to the motion to disqualify. Okay, I turn to page 2. Remember, this thing's filed November 20. I turn to page 2, and the date of page 2 is October 14th, 2025. So it's 5 weeks before the filing. And whereas the title of the document refers to the motion to disqualify, and again, I'm going over this for a reason. And you will see the lack of care throughout. And it just has to bleed over to the performance that occurred to GTII and to their interests with regard to shareholders at all times and to Reichman's choice of these guys. I mean, it makes you wonder that the reason why Reichman chose these guys is because he completely controlled them and they had no interest in following their duty to the shareholders of the company. But I don't know. Just guessing. So motion disqualifies what the document says it is. You turn to page 2, which is dated 5 weeks earlier, which obviously is another blown, something that's not reconcilable. But it says, please take notice that the real parties in interest shall move this court for an order dissolving the existing injunction. So the document says it's an opposition to a motion to disqualify. The second page says they're moving to dissolve the injunction. Completely different. Completely, it's the wrong page. So what they did is, and maybe they don't know, maybe Oliphant doesn't know what he's doing at all, and he thinks this is the right page because it's page 2, but it relates to something completely different. It's completely undated, a different date. So complete lack of care, completely inconsistent, complete nonsense because it doesn't even relate to the title of the document. Not, and it's got one of those BS signatures on it also. So did anybody look at this? I mean, did Oliphant look at this? Did Markowitz look at the document? Or is this how they do everything? They just throw it over. They just kind of toss it. They spend zero time exercising any degree of due diligence because obviously they didn't spend a second looking at this document. I'm going to continue on. So now I'm on page 3. And again, I'm just going to call out all the error and lack of care. So Scott Oliphant, this is what he says. Line 1. It's actually line 4, but it's the first line of his points and authorities. Facts. It's not really a fact, it's an argument. But Scott Oliphant provided legal services to GTII for the share he received. Now, misspelling. I'm just going to point out the misspellings. Shares. You got more than one. As a matter of fact, he claimed in a document, in an email, that he got 12,500. In this document, he acknowledges, that was a mistake. It was actually 125,000. The lack of care here is amazing. And it goes to Markowitz, Reichman, and Oliphant. It goes to all of Buddy and anybody who worked with these clowns. So he goes in, he describes it as that he claims that the receiver, labeled his shares as dubious, and there's no evidence to support that. And although he does acknowledge in the conflict, so there's a couple of issues. So are his interests different than interests of GTII? And because he's chasing shares that may have been illegally provided or improperly provided, not properly provided based upon what the receiver says, then should he be able to contest that? Isn't that against the interests of GTII? And weren't you exposed to inside information in your position as GTII? Now, at one point in time, it's kind of funny, and I'll get to it. One point in time, Markowitz claims that the only source of information that Oliphant got was through public sources that anybody can have, and through what Markowitz says. And then Oliphant completely contradicts him. That says that he prepped Reichman for a deposition, and he probably got inside information through that, or may have gotten. I don't know how he couldn't have gotten inside information if he properly. And again, he might be saying he didn't properly prepare Reichman for his deposition. If that's what he's saying and he's admitting malpractice, then so be it. But if he's claiming that he properly prepared Reichman for his deposition, I don't know how he could have not acquired insider information regarding GTII. Doesn't make any sense. Preparation for a deposition is usually pretty intimate, pretty open, because it's subject to attorney-client privilege. So people aren't concerned about their disclosures. So the fact that he claims he's not sure if he got insider information sounds like nonsense to me, and directly contradicts what Markowitz said, that the only source of information was public information, and what Markowitz said. So just more nonsense. He does acknowledge that and the standard is, a lawyer who has formerly represented a client in the matter shall not thereafter represent another person in the same or substantially related matter in which the person's interests are materially adverse to the interests of the former client. And here what the claim is that Oliphant is representing Markowitz and CYA as to their shares, and that there's a conflict because them keeping their shares is in a conflict with the interests of GTII. What's also interesting is he has indicated, and he's provided a declaration, he being Oliphant. So he's a witness. And if you can't be a percipient witness and counsel, that's a conflict of interest also. Why is that a conflict? Because if you're a witness in a matter, your credibility then becomes an issue. And if you're representing other parties and your credibility becomes an issue, then your ability to represent them as an attorney is injured. So there's obviously a conflict if he's a witness and a percipient witness. And he hasn't mentioned this, but has he obtained a conflict waiver from GTII, Markowitz, and CYA? He didn't. It's not here, not referenced, but obviously a conflict. He's acknowledged the conflict by saying he's a percipient witness and by providing a declaration of that. So, but no reference to a waiver. And if you don't get a waiver and there's a conflict, and there's no valid waiver. And GTI certainly wouldn't waive it. So interesting, I would say. Page 5. Mr. Oliphant, so this is what the document says. Mr. Oliphant did not have any access to information as to DTI's internal operations or negotiations. That's what the document says. I'm going to get into what the declaration says, but that's what the document says. And then they say basically also that there's no evidence that any of the shares involved treasury stock. And if it involved treasury stock, the issue would be if you gave it out and didn't get consideration, then there would be dilution. And they're claiming there's no evidence of treasury stock, even though later on they acknowledge there is treasury stock. And I think that related to that transaction involving Tommy Wang, where he financed like a $10 million share sale, $2 million. I mean, this is reflective of what the receiver said. There was a 10 million share sale, $2 million went to either Reichman or Markowitz, 1.8 ended up going to Reichman. $200,000 went to Markowitz. For what? I don't know. For GTI's benefit? Of course not. For GTI's detriment? Yes, it appears to be. But anyway, he claims that there's, he had no information, and there's not treasury stock, but later they contradict themselves. And again, in this case, which is interesting, Oliphant is in pro per, so he's representing himself, but he's also representing other parties. So he's counsel on a witness, and you can't be both with a waiver. At least you can't do it properly without a waiver, and you can't do it properly if you can't do it competently. Now I'm going to the declaration of Markowitz. So again, this is filed with regard to the motion to disqualify, not with regard to apparently the opposition to the court's action freezing the shares. And he says, so I'm reading from his declaration. This is under penalty of perjury. Before I say that, let me make sure, because he signed it. I remember they signed it kind of like oddly. So I'm just going to read it, how they signed it. I declare the foregoing subject to the pains and penalties of the laws against perjury of the state of Nevada. Normally, what I would say is I declare under penalty of perjury that the foregoing is correct, true and correct under the laws of the state of California, Nevada, whatever. But anyway, he said it that way. I know of, so I'm reading from his declaration. So this is basically him testifying under penalty of perjury. I know of no conspiracy involving GTII being investigated by the receiver. I think I've seen 4 reports. So how could he not know of investigation? Because there's a whole thing is an investigation, and the receiver has accused Markowitz of engaging in misconduct. So how could he not go? It's public. So the fact that oh, by the way, I know of no conspiracy involving GTII being investigated by the receiver. Again, that's false. If he doesn't know, then he must have forgotten. And if he was involved, how could he not know? If he doesn't know, then he doesn't read and is, I guess, hidden away in Hawaii in a cabin with a closed door and headphones on, blinders on, and not paying attention, because he obviously didn't pay attention to this. My relationship with this is number 4. My relationship with GTI, and this is Markowitz. My relationship with GTI has been opaque. It's been straightforward since the beginning. I have provided advisory services to the company on an ad needed basis. The one thing I could say is nothing about GTII is transparent. Nothing, including Markowitz. 0. And the claim that he's been transparent is nonsense, utter nonsense. And it continues with this. One thing that nobody at GTI has been is transparent, at least of the main crew, Reichman and his clan and everybody who assisted him, including the professionals that apparently assisted him in some way. They haven't been straightforward, haven't been clear at any time. And the suggestion to the contrary is bullshit. Now, think about this also. Number 6, the relationship ended, and I was referring to his relationship with GTI, when I requested that Mr. Reichman deliver to me either payment for my shares or shares owed to me. He declined, at which time I stopped providing services. So in other words, he provided services, Reichman stiffed him. So he knew right from the start that Reichman, if this is true, that Reichman was a scammer, because he says so. He performed services and Reichman said, BS, fuck you, take off. But he didn't take off. He stopped performing services, but that was it. But he knew from that point in time, he knew what you were. Now, when he said that he performed services on an ad-needed basis, it's contradicted by, and you'll see, it's contradicted by Oliphant, who says that Markowitz was in-house counsel. In-house counsel is the counsel that represents the company on a day-to-day basis as an employee of the company. It's not outside counsel. It's not like hiring an attorney to perform a service. In-house counsel is an employee of the company. So the fact when and that's what Oliphant says in the same document, in his declaration under penalty of perjury. Markowitz says here that he only provided advisory services. Oliphant contradicts him directly. Now, with regard to the advisory services that Markowitz claims to have provided, did Reichman follow that? And if he did you advise him to engage in improper, unethical, illegal, inappropriate misconduct? And did the actions of Reichman are they based upon the advice that you provided him? Do you dispute that? Do you dispute that Reichman? I mean, you claim that he stiffed you, and you'll see that he has other claims too as we go through this. So, I mean, how could you stay? How could you act on his requests? You were there, and what did you tell him? Did you suggest for him to engage in the conduct that he engaged in, that the receiver says is inappropriate, improper, unethical, whatever else you want to add to it? Number 7, the litigation that Mr. Strickland claims was averse. Now, I'm pointing it out again because this is Markowitz obviously didn't pay any attention to what the content was here or didn't care. It's not averse, adverse to. It's the use of the wrong word. Anyway, if someone had any care for the work product they were providing, that's a mistake. Another of the mistakes they would have caught. They would have said, because it's important, if you're filing something in the court, if you don't file with accuracy, that suggests that you didn't perform with accuracy. I know it's a little thing, but it's not really. It's just sloppy. Sloppy. Lack of care, lack of interest, lack of entitlement to any consideration. Anyway, so number 8. So there's an issue of litigation that was brought in New York I think, to GoFund. And the litigation, so I'm reading from the declaration, again, under penalty of, or pains and whatever he said, but it's under penalty of perjury. The litigation filed by Reichman, this is after Reichman stiffed him, by the way. The litigation filed by Reichman on behalf of GTI was based on the fact that Reichman would not authorize the issuance of shares promised to the GoFund principals in the arbitration, and therefore GTI would not fulfill its obligation to the principals of GoFund. So he's saying, and I don't know if any of it's true, but what he's saying is he knew that besides stiffing him, Reichman stiffed GoFund. This seems like this was a business practice. And obviously, Markowitz and Oliphant indirectly would be aware of if these were business practice. And these are not proper business practices. Can't make agreements and then not perform. And that's separate apart from the issuance of shares, et cetera, and that 10 million, again, that $10 million transaction, 10 million share transaction, where 200 grand goes to Markowitz for what? 1.8 goes to Reichman for what? Anyway, number 12, and I'm just picking up selective pieces because I could spend a day going through this nonsense. I have no knowledge of any such scheme to leak millions of shares to affiliated parties, nor was I a party to one. That's his citation. So was there less than 10 millions, less than millions of shares? Were there hundreds of thousands of shares? Were there more than millions of shares? Are you claiming that the number is wrong or the thing did not happen? I can't tell from what you're saying. It certainly is not definitive. Kind of leaves the door open. Did you not render advice to David Reichman about the shares? I know at some point in time in, I think it's 2024 early, if you recall, there were millions of shares that were issued without any basis to management, and eventually Rabari I think through Rabari they had those canceled, like 36 million shares. You weren't aware of those? Where were you? Where, Mr. Markowitz, where were you when those shares were issued to the board since you were in-house counsel? Where were you? And what did you do? And what about Oliphant? Why didn't you step in? What kind of advice did you give him? Did you tell him not to do it? Did you resign? There was a letter that's referred to by Strickland that's basically deals with the transfer of shares. And Markowitz's explanation was, again, he continued to work with Reichman, despite the fact he stiffed him, stiffed others. His business practices seemed to be completely improper. He authorized and issued shares that shouldn't have been issued, et cetera, et cetera. But Reichman's chasing him down, and he says, the letter was provided by me. So this is where he's basically setting it up. So if he dies, the shares go to Reichman, et cetera, in the board. The letter was provided by me to literally shut him up and allow me to travel with my wife about a week later. So he gave a letter to Reichman with regard to shares that was false, because he says it's false. He just wanted to shut him up. 15. As for the shares described, so these are a bunch of shares that were described that are reflected in the letter. I did act as trustee. So it says, it doesn't say I did not act as trustee. So this is really important. It's talking about shares. And he says, I'm just going to read it, paragraph 15. As for the shares described, I did act as trustee. So stop. If you're acting as a trustee, you have a fiduciary relationship to the company board, to the shareholders. So when you were saying that you were merely you did some advisory work, you're a trustee. You have a fiduciary obligation. You signed this document under penalty of perjury, and you never took any action other than hold them on behalf of GTI as I did. The decision as to where they would allegedly go was solely directed by Reichman. Okay, that makes no sense to me. He's the attorney, in-house attorney. He's also the trustee. He's not just some joker. He has a fiduciary obligation. The decision as to where the shares would go would be not as to Reichman, they would be as to the trustee. He has this reversed. So I think he's acknowledging the way 15 is written, he's acknowledging a breach of his fiduciary duty, the way I read it, under penalty of perjury. He can, try, and again, it may be just because he spent so little time, so little effort reviewing the documents that they don't say what he intends to say, but that would suggest that he shouldn't have represented anybody in this matter. And Oliphant too, because Oliphant apparently drafted this document. Although I don't know who drafted this particular declaration. It could have been this gentleman, but it admits apparently a breach of fiduciary duty. 16. I had no authority to direct or otherwise demand that GTII or Reichman, for that matter, disclose any action. I was not, never held such authority. You just said you were a trustee above. Of course you had the authority. And of course you could have resigned. In other words, if you're representing a client, the client's engaged in misconduct, then you resign. That's what you do. You don't hang on and wait for the benefit of the transaction. You can't do that. You can't sanction the misconduct. You can't basically support the misconduct. That's not a proper way of acting. But I got the idea from the way Markowitz, Reichman, and Oliphant conduct themselves that I guess this is the way they act. So the fact that they might have a fiduciary duty to somebody apparently is irrelevant. 18. As for the Tommy Wang transaction, as detailed and commented in paragraph 9 and 10 of the Strickland affidavit, there was another affidavit. As I informed the receiver when asked about it, I completed the transaction on behalf of GTII. What nonsense is that? If you recall, I think the receiver claims that $2 million came out of that. 1.8 to David Reichman and 200,000 to Markowitz. That's what the receiver claims. How could that be for the benefit of GTII? How isn't that a direct ripoff? I mean, by Reichman. How isn't, if that money should have gone to GTII as the receiver claims, how is that not improper? And how could Markowitz say that? Anyway, 19, upon informant and belief. So again, another misspelling. It's upon information and belief. The source, again, it's not source. It should be shares sold to Mr. Want. It should be Wang was GTI. I'm going to read that again. So I'm going to read it what it says, and I'm going to read it what it should say. Upon informant and belief, the source sold to Mr. Want was GTII. I think what it's trying to say is upon information and belief, the shares sold to Mr. Wang, I don't know, was GTII. That still doesn't make any sense. But all it does is shows that not only did Mr. Markowitz not pay any attention, again, but Mr. Oliphant didn't pay any attention, again. That's pure gibberish. I think the court should comment on that too. If I were the judge and this had come into me and there were just like a terrible work product, terrible, below, in my opinion, this is below acceptable standard for a Nevada attorney. Number 20, all actions taken as to shares and money were done with the contemporaneous knowledge and consent and authorization of Mr. Reichman. So he's trying to cleanse his activity by saying Reichman signed off on all this after saying that Reichman stiffed him, he stiffed others, even if an arbitration award came in there. And despite the fact that Markowitz says he was a trustee and therefore had a fiduciary obligation, he claims that Reichman sanitized everything. Well, Reichman didn't sanitize anything. You signed on to it and you stayed. And to the extent you're a party to the misconduct that the receiver says that Reichman undertook, then you're stuck with it too. It's worse. I don't know why these guys are practicing. To the extent they're practicing, why are these guys allowed to practice? Really? Disgusting. 23. The transaction was handled in this way as Reichman. So this is what Markowitz is saying. Despite the fact he stayed and took no action to sanitize any of this stuff or clean it up, help, as far as I know, as far as what the receiver is stating, the transaction was handled in this way as Reichman had a reputation of not paying people for services, attempting to renegotiate matters after they had closed, and to hold on to share compensation until he decided he was going to release them. So Reichman's business practices, Markowitz is saying, he acted completely improperly, but he stayed. But obviously, that didn't stop Markowitz from continuing to help him out. Despite the fact Markowitz claims basically he screwed everybody. That was his business practice. Markowitz, that didn't seem to bother Markowitz as long as Markowitz got paid. Remember, Markowitz says he got 200 grand, if you recall. I don't know what else he got. Then he talks about like completing the sale, that sale. Then he uses his language in paragraph 23 that kind of, I just found it really uncomfortable. So 23, the transaction was not a private and secret sale stated by Strickland, paragraph 11, or the Strickland affidavit. It was for a fulfillment of a transaction as I saw fit. What? He had a fiduciary obligation to the company and the shareholders. It's not a transaction that was for his personal benefit. If he doesn't understand that or know, that's a big problem for the guy who claimed he was a trustee, and the guy claimed he was in-house counsel, and the guy claimed he was aware of all the improper practice Reichman was engaging in. Ludicrous. The guy admits he's aware of the misconduct, does nothing despite a fiduciary duty. 24. Strickland's contention. So recall, Strickland's reports, he completely eviscerates Markowitz, claims he engaged all kinds of misconduct. 24. Strickland's contentions of tortious or legal conduct as to my actions appear to be without any admissible evidentiary support, which is interesting. He doesn't say it's not true. You know, wouldn't that be a better statement? If I accused, let's say I accuse somebody of committing theft, would it really be a defense, a really heartfelt defense, if the response was, well, you don't have any admissible evidence in support of that? That to me suggests that you're engaged in the misconduct, and you're arguing about whether the receiver can prove it or not that you didn't engage in it. Again, you were a trustee because you acknowledged that. You were in-house counsel because Oliphant says that we haven't got there yet. Oliphant says you were in-house counsel. So you had a fiduciary duty to the company and to us. 31. While in the process of attempting to sell some of my shares, identified in paragraph 28. So those were the shares that somehow went from some guy named Lester, and I don't know about him and if he's still alive and if it's legitimate. Somehow it went to CYA Holdings LLC, which I read as Cover Your Ass Attorney Holdings LLC. And apparently apparently Markowitz tried to sell shares that somehow had arrived to CYA, Cover Your Ass. And Reichman contacted, he tried to sell them. Reichman said, don't, unless the proceeds were distributed as Reichman wanted. I got to read this to you because I'm like amazed that they actually admitted to this. While in the process of attempting to sell some of my shares identified in paragraph 28, those are the CYA shares, Mr. Reichman contacted me telephonically. He informed me that he would not permit me to consummate the sale. Mr. Reichman informed me that he would not permit the transaction to be consummated unless I agreed to distribute the proceeds as directed by him to the parties that had no interest in the transaction, including himself, Mr. Reichman. Did he do it? Did he just follow? Did he follow the directions or not? It suggests that he did. And he knew they were improper. He knew they were contrary to the interest of GTII. He knew there would be a breach of duty to the company. He knew that Reichman was not supposed to get that because he says that. He says that none of the parties had interest in the transaction. So he's suggesting he knowingly engaged in misconduct. And I don't know if it's because he was going to get some money out of this transaction. It's kind of what's implied in this deal. Distribute this, because otherwise, why would he distribute it if he wasn't going to get anything out of it? So it suggests to me, and I don't know this for a fact, but it suggests to me that he distributed the proceeds as Reichman wanted him to so that he would benefit also. If he didn't, he should have stated it here because it leaves that impression. 34. Upon information and belief. This time he spelled it correctly as opposed to remember, informant and belief. The Hans and Rosie Epstein Foundation is a charitable foundation. Upon information and belief means you don't know. So that's not a personal knowledge. So he doesn't know. So despite what it says, he doesn't know if it's a legitimate a charitable foundation. And he doesn't indicate what, if any, work he did to ascertain if it was. It doesn't indicate, it hasn't said he didn't help distributing shares to them. None of that. But he just says he doesn't have personal knowledge as to whether it's a charitable foundation. I'm continuing on 34. I have no knowledge as to whom founded it or operated or operates it. What info do you have? What do you know about it other than what the receiver said? Did you have any contact with these people? Anybody? Were you involved in any of the share transfers? The fact that you didn't know who operated it, were you aware of the fact that shares went there? Obviously you did, or else you wouldn't be referencing it. Why are you referencing the foundation out of the blue? Just out of the blue. It has nothing to do with anything else in this document other than suggesting that the shares they got were somehow legitimate, even though you don't know. And even though everything else suggested in here that you did was you indicate that Reichman engaged in all this kind of improper conduct, but you still hung out. You stayed. It appears that as long as you got your money, you were fine. You didn't care about anybody else. That's what it suggests. That's what this declaration that you provided to the court under pain and penalty of perjury under the laws of the state of Nevada. That's what it suggests. Or again, a lack of care in the preparation of the document, which again suggests that when you suggests that when you were operating in-house counsel at GTII, that you undertook the same amount of care. And I remember that you prepared for people some kind of, well, I think you indicated, or somebody indicated that, yeah, somebody did tell me at one point in time that, and I think it was you, and if it wasn't you, it was somebody else at GTI, they checked the wrong box saying it was a shell corporation. And when the dividends were to be issued, because that box had been checked, it became a problem. I don't know if it was you, Mr. Markowitz, who checked the wrong box. And I don't know why you didn't correct it. And I didn't know why that opinion didn't have any impact. I think you prepared some kind of opinion letter. That's different apart from the opinion letter taking off the restrictions of Oliphant's stock and that he did for you. That's separate and apart, which I question the validity of based upon what I see here and what the receiver's 4 reports say. Paragraph 35. At one point, comma, okay, I'm reading it again, just showing you the brilliance of this document and the care. So what it says, at one point, comma, 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 a contemplated transaction arose for GTI shares between Sunbelt Equipment Leasing, Robin Biso, and Wayne Crumpley. Then he says he had no knowledge about that. 37, the opinions for Ms. Justine Reichman and Dot 8 were done with sufficient review of public information that provided acceptable determination that the letters were proper. Now, I think there have been detailed reports that there's been nothing that's been provided that justifies the shares that were provided to Justine Reichman and Dot 8. That's what the receiver said. So if that's the case, then how could you provide any letters taking off any restrictions if the shares themselves weren't properly provided? Anyway, he also says, paragraph 37, I have no knowledge of any illicit or fraudulent transactions as Mr. Strickland asserts. I mean, I've just gone through this document. You've referenced non-payment. You've referenced him stiffing people. So I don't understand why you say that, because internally it's inconsistent with your very own declaration that apparently you signed, apparently you looked at. Did you look at it? I have no knowledge. Okay, I did that. I retained, that's paragraph 41. I retained Mr. Oliphant to act on behalf of GTII after the federal court denied my pro hac admission. So now this document here, the entirety of it, is prepared by Oliphant. It's, in my opinion, it's pure garbage. My opinion, pure garbage, full of mistakes, full of inconsistencies, full of internal inconsistencies. But that's who Markowitz, for whatever reason, decided to hire. Now, he says that he hired him because he didn't get admitted. Pro hac vice. He left off a word also. Paragraph 41. Why didn't he get admitted? What about him? So what happens is if you're outside of jurisdiction, so let's say I'm in California, there's a case in Nevada and I want to be able to appear in court in Nevada, I can apply in Nevada to get admitted just on that case per se. And most times, most if not all times, unless there's some big issue, you'll be admitted. Here he's saying he tried to get admitted, but he was denied. I want to know why he was denied admission. What was the basis for the federal district court to deny admission? I think that's an interesting point to see why the court didn't think he was competent to handle the matter in district court. 42, and I'm waiting to hear about that. So that would be interesting. And if he's deposed, by the way, just off the side. So Oliphant and Markowitz, their depositions are set. I'm certainly going to attend them, and I would not be surprised if in fact that there's an issue that arises about that. Okay. Paragraph 42. He received his knowledge of the matters. So now I think, so it's unclear who he is. Markowitz deposition, unclear who he is. He worked and got his information through documents, conversation, and supporting information that I provided him, and I functioned as his sole conduit to GTII. So that's what Markowitz claims in his declaration. Moving on, and the last part, remember there was a claim that there was no treasury stock that was implicated, paragraph 48. Apart from the internet capital transaction, none of the transactions identified in declaration or disqualification motion involved GTI treasury stock. So the internet they're acknowledging. So basically saying the internet capital transaction did involve the GTI treasury stock and therefore was dilutive. Moving on to Oliphant's declaration quickly. He claims he received his shares providing valuable legal services. I don't know what those valuable legal services, because based upon the quality of his work product, nothing here is valuable. It looks like incompetent. Paragraph 10. Mr. Strickland's observation as to my September 30th, 2024 email that I received more than 12,000 shares is correct. So he claimed being Oliphant, they only got 12,500 shares. The receiver claimed you got 125,000 shares. He denied it. He now claims it was a typo, that it should have been 125, not 12.5. Okay. So just another error in a material document. 11. I also realized that there's another typographical error in the engagement letter. The date in the letter is 2021. He's basically saying, so he couldn't find an engagement letter that properly fit the time for the for his work at GTII. So he had and the receiver claims it may be a backdated document because it says 2021, not 2022. He's claiming again, it's another typo, that it was not 2021, it was 2022, and it's another goof. Again, could it be another goof? It might be, but it just establishes complete incompetent performance, period. So in the documents, he's talking about the documents he made errors in, he made more errors in, and also apparently made certain admissions, as I've pointed out. Paragraph 11, this is supported by the fact that the first services I performed for GTI, I was filing a motion for relief from default in federal court that mutually acknowledged an undisputed certificate of shares. So what's a motion for relief from default? Because I don't know when he was involved, who was involved, but that means when you fail to timely respond. If you fail to timely respond, then the other party can enter a judgment against you. That's for a goof, not because you acted properly. So he's saying that after there was another goof, that's when that he got involved with filing a motion. I don't know if he was supposed to have filed the response earlier, if Markowitz was, if somebody else was, but somebody dropped the ball because no default should have been entered if there was proper representation. So what was Reichman doing here? I don't know. How come nobody was paying any attention to any of this? I don't know. Paragraph 13. Part of the argument about the conflict of interest is that he was made aware of facts about GTII through a complaint. Paragraph 13. As to the draft complaint I was provided in 2024 of a review, I was not hired by GTII to perform any review at all. So he's claiming that even though he was given the draft complaint, talked about Markowitz about the complaint, he still got no inside information about GTII. That's what basically it says. Sounds like nonsense to me. Paragraph 14, regarding the 144 letter I signed pertaining to MZAA, the letter that took off the restriction. He says, I am reasonably and objectively permitted to rely upon the representations of in-house counsel, Mr. Markowitz, who provided me all the information as to GTI necessary to author the letter, with the exception of the references to public filings and disclosures, which were true and correct at that time. So he's claiming that he relied upon in-house counsel for GTII, not the advisor that Markowitz proclaimed himself to be in this very same document. But he's the in-house counsel who has obviously a fiduciary duty to the company, to the shareholders, etc., and is a permanent fixture, not just a guy coming in and out. So he claims that Markowitz and public information provided him all the information that was necessary. However, paragraph 15, the very next paragraph, it says, as to all my dealing, and this again, this is under penalty of perjury. This is not just like argument. This is an admission of fact by these jokers. As to all my dealings with GTII, my sole source of information as outside counsel was Mr. Markowitz. I obtained no additional information directly from anyone. Now listen to this part. So only got information from Markowitz. He didn't get nothing, no other information from anyone else, with the possible exception of preparing Mr. Reichman for a deposition in the course of litigation, over 4 years ago. So another error, because it says we, I don't know what that means, but he says the only information he only relied upon was the information that was provided by Markowitz and public information, except for when he prepped Reichman for his deposition in the course of litigation. So when you prep somebody for a deposition, again, it's attorney-client privilege. It's very intimate. You want full disclosure of everything. And they're talking about shares. So the issuance of shares would come up. The justification would come up. All prior lawsuits would come up. Prior issues would come up. That's what you would discuss in a prep for the deposition. Clearly, you'd be provided inside information as to the operations and ongoing efforts of the company. If you didn't, you wouldn't have done a proper job preparing the deponent for his deposition. So unless he's admitting malpractice in the preparation of the deposition, which he might be, I guess, there's no way he couldn't have not received inside information. And I think this is the fact that he's acknowledging that. And then kind of misleading everybody by saying that, and Markowitz did the same thing. Markowitz specifically said his only source of information was me and public information. In the same document, Oliphant is saying what Markowitz said is not true, because I may have got information from the depo prep, probably from the how about from the deposition itself? It's not just the deposition prep. He attended the deposition. In a deposition, you would discuss the history of the company, actions, etc. How would you not get inside information? How would you not be aware of information? So I think that's complete nonsense. And again, completely inconsistent with what Markowitz said in the same document. Paragraph 18. Contrary to Mr. Strickland and Mr. Siciliano's contentions that I have no respect, regard, or recognition of this court's jurisdiction, I do respect this court's jurisdiction. My sole contention was that I was the former agent, and as such, the court had no personal jurisdiction over me absent a summons. I read the email. My interpretation of the email that he sent back to Siciliano was F off. Don't bother me. Court has no power over me. Not what he just said. And again, I was amazed by his language he used about the court. And I'm looking forward to how the court evaluates that and evaluates its ability to have jurisdiction over this. I'm not going to call him a clown. Paragraph 20. So we heard that he deposed, he prepared Reichman for a deposition about shares, and then apparently attended the deposition. Paragraph 20, same document. All my knowledge regarding GTI came from EITH documents provided to me by Mr. Markowitz in the course of representing GTII in these two TO cases, or the discovery process in the two, spelled correctly, cases, by virtue of disclosure, are not privileged. Makes no sense, by the way. And it's, again, directly contradictory what he said in paragraph 18, where here he's saying it only came from Markowitz in the documents. Paragraph 18, I'm just going to read it again. I obtained no additional information directly from anyone in the company. Pause. With the possible exception of preparing Mr. Reichman for a deposition in the course of litigation, over 4 years ago. So paragraph 20 is directly contradicted by paragraph 18 within the same document. Did anybody look at this? Did anybody look at this? So after going through this document, all that you can conclude is the work product is pure crap. Pure crap. That they were aware. I mean, Markowitz says he was aware of improper business practices. He actually refers to the actual conduct of stiffing people on shares, including himself. He's aware of this. They gave no reason for hanging out other than getting paid, making money. He was a trustee, he took no action as a trustee. I think this document is hugely damaging to both Oliphant and Markowitz. And I would not be surprised if these guys took the fifth. I mean, if they engaged and supported criminal misconduct, as the receiver suggests, I think the receiver suggests they supported and helped Reichman engage in all kinds of misconduct. If that's the case, and if it might go beyond just civil, and again, I don't know, I'm just saying what the receiver says, but if it goes beyond just like civil to, potential, iron bars, I would not be surprised if these guys took the fifth, if they were smart enough. I don't know if they're smart enough to do it. But if I were them and this was laid out and I'd filed this crap, kind of setting up a whole bunch of issues, I would take the fifth. I wouldn't testify if what the receiver claims is true, and based upon what the nonsense that's referenced in this document, I think they should take the fifth. That's what I would do. And I would think also, just suggestion to Mr. Oliphant, you probably should hire counsel. And Mr. Markowitz, you should hire separate counsel. Just my critique, I think Oliphant's work product sucks. And your supervision of his work product sucks also. And if anybody else reviewed this document before it went out, they're incompetent. So I'm going to leave it at that. Attending the deposition tomorrow with regard to the Rose Epstein Trust, all those shares they got, and we'll talk about that tomorrow. And that's it. Thank you very much. Have a great day. And we'll see you later.